Yes, please.
Item number 1.
Last one.
In terms of the order dated 24/6/2025, the state has filed a status report, Millets.
You've got a copy?
I've got a copy, Millets. I've been served a copy.
We have served, Your Lordship.
They say, Millets, we had brought to the notice of this honorable court some deforestation activities that was taking place in a place in Shillong, Millets, called Lausatun. They filed a report, Millets, saying that this was part of a greater scheme that was sanctioned by the central government for the purposes of the Shillong cable car company, ropeway, Millets, for the construction of the ropeway project.
Yes.
And Millets, they've annexed certain documents, Millets. I'm yet to run through the entire affidavit. If my lords kindly grant me a week's time, Millets, we can assist your lordships on this. Millets, para 4 and para 5 at page 4 and 5 would be relevant for our purposes. I'm sorry, Millets, para 3 onwards.
Under this, they have done it.
We filed it by working after putting the pictures on the corporate.
As the affidavit discloses that roughly about 330 trees have been felled.
.23 hectares was also handed over for.
My lords, they say, my lords, in West Khasi Hills, that land's been handed
That is,
over for compensatory afforestation.
It's quite big. It's a lot. Barak tree.
This order was also extended to the whole of Meghalaya.
Let them dig with the report. The scope of this public interest litigation now covers the entire state of Meghalaya. By our order dated 24th June 2025, we had expressed our deep concern on the allegation made by the petitioner that in the Los Sotom area of East Khasi Hills district, there was indiscriminate and large-scale felling of trees to the extent of changing the entire landscape of the area. Paragraph. We had also produced the report of the state government dated 20th June 2025, filed pursuant to an earlier order of this court. By that order, a state-level committee had been constituted by the court to supervise the process of dealing with applications by individuals for felling or part felling or lopping of branches of trees said to cause danger to life or property or both. While dealing with the report, in our order dated 24th June 2025, we had directed the committee to be more proactive instead of delegating the work to subordinate forest officers. We called for a further report to be considered today. Accordingly, a further report dated 18 July 2025 is filed in court today. It is quite an extensive report. Mr. Paul Learned, Senior Advocate appearing for the petitioner, wants to peruse the report in detail. Full stop. Accordingly, such time is given. Paragraph. However, it does appear from this report that the large-scale felling of trees in the Lausotum area of East Khasi Hills district was done with the approval of the appropriate authorities where do we find that it's a central government project?
Well, it's, they've annexed the permission that has been given, Mills. Mills would find it at page 23.
Start from page 14.
It starts from
Page 14.
page 14, Your Lordship.
14 is the
23 is the provision.
14 is the correspondence between the state government, Mills. My lords, may kindly come to page 23.
On 23, Your Lordship, is the permission, Your Lordship.
starts from page 23 minutes till
23 to
page 30. The stage 1 and the stage 2 approval minutes under the act is there. Page 23, stage 1,
Final approval has already been granted.
and stage 2, my lords would find at 27.
27 is the final approval.
Stage 2 approval.
Mr. Kulni, you have sought the approval of the government of India
Yes, my
to
lords.
execute your project.
Yes, my
It's
lords.
not their project.
It's not their project. My lords. The tourism department of the government of Meghalaya, my lords,
Our
approved.
project, Your Lordship, yes.
Yes, what
It's
is it?
our project. Lordship, in the order dated 9/4, if Lordship kindly
To facilitate construction of the Shillong Peak Ropeway
Lord
cable car
Chief.
project at Raid Laban Reserve Forest by the tourism department of the state government upon obtaining appropriate approval for forest clearance from the central government. Paragraph. Furthermore, it also prima facie appears from the report that the committee has been considering applications for felling or lopping of branches of trees with more attention and upon scrutiny of all details. Paragraph. We make this public interest litigation to be turnable on (30th July).
30th of July.
Full stop. In the meantime, the petitioner may file a rejoinder affidavit dealing with the report.
My lords.
May it please Your Lordship. Lordship, in the order dated 9/4/2025, Lordship was pleased to pass the order that where the central government has accorded the permission under the Forest Conservation Act 1980, Your Lordship, for a development project. This order of 7/2/25 will not be applicable. So in view of that order, if Lordship kindly permit us to go ahead with the project.
You are going ahead with the project. We have not stopped you.
Lordship.
There is no order of injunction.
Lordship.
But we have noted that you have obtained this
If-
permission, your tourism department, to
If
construct this.
Lordship, maybe please to make that observation, Your Lordship.
We have said that
Lordship.
for obtaining approval.
Lordship.
But regarding continuance or stoppage, we have said nothing. Let his response to the report come.
They say, my lords, 353 trees to be felled. 330 have already been
Lordship,
felled.
we are
Practically,
going
felling
to
part
shift
is already complete.
To the newly acquired place, Lordship, somewhere in
Well, it's the other aspect which I wanted to point out. It's in another connected PIL before this honorable court, it's a tentative view was taken by this honorable court that afforestation melodies in another district may not be adequate for the purposes of restoring the ecological
Obviously.
balance of the state. I'll bring that order to the notice of this honorable court, Millets. Because ideally, it should be in the same area so that at least the
It's like the east wall of your building is damaged and the west wall is being plastered.
and whether the west wall is at all being plastered, Millets, is something that none of us know, Millets.
All right, you add in one case that that cable car and all that. There you add that it is also stated in the report that the central government has provided
Report.
compensatory land to the state government for afforestation. Full stop. To this, Mr. Paul submits that this land is situated in another district and would serve no purpose in improving the environment of the said area of East Khasi Hills district.
All right.
I'll leave that.
Number 2.
Please, Your Lordship. Your Lordship, we have filed an affidavit on last week, on the 16th of July, bringing on record the steps taken by the different districts, Your Lordship, for constituting a monitoring committee, Your Lordship. So from all the districts, we have received reports, Your Lordship, except from the South Garo Hills district.
Millets, the affidavit discloses that the committees have not been formed for West Jaintia Hills district, Millets, and South Garo Hills district.
South Garo Hills, we haven't got it.
So these two districts, Millets, are yet to comply with the directions that have been followed from this honorable court.
The rest of the districts.
Sorry? The latest affidavit. Where can I get it? Which 56. Just keep it category. Where? Page. Page.
West Jaintia Hills at page 48, Your Lordship. They have taken some steps, Your Lordship.
The committee has not been
The
formed.
committee has not been formed, that is clear. But some action has been taken in
Paragraph
compliance
9.
with the court's order.
Paragraph 9 of the order of the affidavit, if my lords kindly have a look at page 8, Millets.
It.
The southwest. I want.
by our earlier order, we had directed constitution of committee, one committee only.
No, my
No,
lords,
the
in
different
all districts, all districts, my lords.
All
are
the
directed.
districts in Meghalaya.
Well, lords, if I may draw your lordship's attention to the order dated 15/5/2025,
Which is an extra one, Your Lordship.
page 3, my lords, last paragraph. Starts off with in those circumstances.
They've dealt with the rest of the district. But the issue
You have that rule 4
My
of
lords,
animal birth control.
my lords, it's there in the PIL, my lords. My lords would find that at page 49 onwards of my PIL. Page 50, the relevant rule, my lords.
Page 49.
Page 49, the
50,
rule
my
starts, my lords. Rule 4 is available at page
Relevant
50.
page is 50, Your Lordship.
50.
Rule 4 is there.
Formation of committee, my lords. It's under the heading of formation of committee. My lords have it. My lords also might want to have a look at, my lords, Rule 2E. That's the local authority, my lords, who's then to constitute the committee under Rule 4.
That has not been done for two districts.
Two districts, Your Lordship. West Jaintia Hills, however, have taken some measures, Your Lordship, in compliance to Your Lordship's order, but they have not constituted a monitoring committee. At page 49, Your Lordship, dogs with rabies have been. At page 49, Your Lordship, anti-rabies vaccination, spraying and castration record for the year 24-25 under West Jaintia Hills District. Lordship, we've given a chart as to the steps taken in different months, Your Lordship. At page 49.
You filed a report.
We have filed a report.
They have filed an affidavit, my lords. It's filed on the
Affidavit
15th
with-
of July.
You form the two committees and we'll make the matter returnable. It is submitted by Mrs. Yangi, learned Additional Advocate General appearing for the state, that the committee under Rule 4 of the Animal Birth Control (dogs) close rules 2001 made under section 38 within bracket 1, framed under section 38 within bracket 1 of the Prevention of Cruelty to Animals Act 1960. Has been constituted for all districts except two. Put the name of those two districts, sir.
South Garo Hills and West
West
Jaintia
Jaintia
Hills.
For the purpose of taking action under the said Act and rules to prevent and control the menace caused by stray dogs by capturing them, treating them vaccinate or inoculate them, vaccinate or inoculate or sterilize them, no, and don't put and, sterilizing them and rehabilitating them in dog shelters. A report in the form of an affidavit has been filed in court. We direct enlistment of this public interest litigation once again on 6th August to receive Further action taken report, including constitution of committees for the said two districts.
I'll oblige.
Oblige, Your Lordships.
Number 3.
Yes.
In this case, my lord, as was directed, we have filed a service affidavit of service, my lord, on 6 and 7. My lord, they have to respond, my lord.
Yes.
Lords, we were directed to file an affidavit of service. My lords, that's been done. My lords had also called for a report from both the state and the centre with regard to the report submitted by the Minority Commissioner, my lords.
Who's appearing for central government?
Yes, I'm appearing, Your Lordship.
Yes.
Yes, Your Lordship, just I got this from this DSG, so I need some time here for instruction.
How much time?
3 weeks, Your Lordship. 3 weeks.
Too much.
In the meantime, Your Lordship, we have just received some instruction. I'd just like to submit some series of orders that have come from Supreme Court
On this issue?
on this issue.
No, please.
Yeah. Actually, what had happened was the 52nd report was of 2016. After that, Your Lordship, on 2020, one Mr. Ashwini Upadhyay, he opposed the Honorable Supreme Court, and so there are 4 orders, Your Lordship, we just like to bring to the knowledge of this Honorable
What is the purport of those orders?
was basically the purpose of these orders was the matter is sub judice before the Supreme Court, and the matter is regarding linguistic minority.
I am not privy to that.
Good.
My friend just. That's the issue. Arkan.
It's mine. Sorry. I'll give it 1, 2, 3, 4. I'll give it the book. It's my copy. Watch this. Please, I'll just give you the other copy. It has been arranged in serial way. I'll just give it to you.
This is nothing to do with Meghalaya.
1, 2, 3.
PIL number 9. Meghalaya. 9 of 2020. Guwahati.
No, sir. In a court copy, give you 1, 2, 3. Too little mark.
Let's see what is 9 of 2020.
Worship, the first order will be 7 January 2022. 7.
This one. What is the subject control? Is it to do with linguistic minority?
Transfer petition, Your Lordship. Why it is important? Because a similar matter was pending in Supreme Court. So, PIL which was pending in Guwahati High Court and Meghalaya High Court. Actually, most important in this 7 January is the writ petition civil number 836 of 2020. I'll come to it in the second order, Your Lordship. 836 of 2020 is the writ petition SLP pending before the Honorable Supreme Court. They said because this matter is pending, both the analogous matter of Meghalaya High Court and Guwahati High Court was sought to be transferred. The petitions were allowed. The Lordship, the second order is of 22nd 11 2022. 836 of 2020 is very important, Lordship. I'll come, and that will be, that in my sequence of order, that will be number 3. The second would be 22/11/2020. Lordship, relevant para is at page 2, para 2. And this was passed in WPC number 836 of 2020. First page, Lordship, in the first page top. Case number is 836 of 2020. The relevant paragraph is para 2.
At the request of learned ASG.
Lordship. Six more times is granted to place the stand in respect thereof. We call upon 19 state governments who have not responded to communicate their status to the central government within the period of 4 weeks from the communication of the order. So the petitioner seeks to rely upon judgment of Allahabad so and so. So, Your Lordship, this was basically under process as to the response of the state government with regarding to 836 of 2020.
This is also linguistic.
Lordship, yes. I'll come to the operative part of the order in my third, Your Lordship. Third order is of May 10, 2022.
Yes.
The third, Your Lordship. 2022 9 SSC 261. Lordship will kindly see the writ petition number is same 836 of 2020. Date is May 10, 2022. Lordship, is a very small order. Just allow me to read very small order. This will clarify the whole context of what is in 836.
Yes.
The petitioner points out by reference to a counter affidavit filed on so and so, most specifically in para 11, that while referring to the religious and linguistic minorities spread all over the country, it has been stated that a religious group that is majority in one state may be minority in another state. The question which was posed was whether Parliament or the state legislature has an exclusive power to legislate on matters pertaining to minority communities and to protect the interests in accordance with the constitutional guarantees.
Yes.
Lordship. In this behalf, it is stated that the Parliament and the state legislature has concurrent powers to enact laws to provide for the protection of minorities and the interests. On the other hand, the petitioner contends that state would have no such power and also relies on a judgment of Allahabad High Court so and so. Another counter affidavit has been filed now by the respondent number 3, which seems to back out of what was stated earlier, something we do not appreciate. It is now sought to be stated that the question involved in this writ petition has, this is important, Lordship, question involved in the writ petition has far-reaching ramifications throughout the country, and therefore any stand taken without detailed deliberation with stakeholders may result in unintended complications throughout the country. We would only say that stand has already been taken in the first affidavit, but in para 7 of this fresh affidavit, it is now stated the power is vested.
So what is to be done, Mr. Khan?
Lordship, this is the last paragraph.
Yes, I have seen it. That being the position, they may make necessary representation to the authorities.
Lordship.
That you make a representation to be considered as a...
Saying, Lordship, so far Meghalaya is concerned, para 6 is relevant for the purpose of Meghalaya. The application...
That is by only a religious minority. Sengraj and what the two, Senkhasi and Sengraj, these are minority religious groups.
Lordship, we are aware.
No relevance with this.
We are aware of it. I'm aware of it, Lordship. Allow me to just complete, Lordship. Though the factual, the present, Lordship, the present PIL is about linguistic minority, and 836 is dealing with that. Now, in para 6 is very important. Is this a religious minority? They approached, and the direction was for. So for the other aspect is concerned, linguistic and minority lordship, the 52nd report is of 2016. A PIL 836 was filed before the Honorable Supreme Court. Supreme Court had directed 19 states to file a counter, and initial after affidavit the matter is still sub judice. My concern is lordship till para 5. Now, this particular issue, this particular PIL was listed last on 12th January 2024. Thereafter, the website of Honorable Supreme Court does not show anything.
Well, the state would be in a better position to say, just to cut my learned friend short, the state would be in a better position to say, whether they were part of those 19 states. A. B. If they have represented or filed anything before the Honorable Supreme Court.
Do we retain our jurisdiction to deal with it, or shall we release it to be done by the Supreme Court?
Well, it's in my humble submission, the matter before the Honorable Supreme Court
Central
is
government
completely different.
stands, Lordship, that is where I am coming to that part, Lordship. I've got a limited instruction on this issue. The stand of the central government is very important here, Lordship.
Yes.
So, and Lordship will kindly see for a moment the PIL, and if I take a Lordship to,
Yes.
if I take it Lordship to the PIL,
R.
and the prayer, Lordship.
No, it is pending before the Supreme Court.
The
don't
larger,
know,
the larger issue of linguistic minority, where 19 states have been called upon to file a stand, and there's a stand, admittedly, the stand taken in this, whether the central government or state government, whether 52nd report is part of it, is also a sub judice matter before the Honorable Supreme Court. Now, the only thing, Lordship, here is this, in this PIL, they are raising the same issue. And one of the important prayer for them is to dispose of the representation, Lordship. There have been 3-4 representation filed by them, and they want the representation to be disposed
No,
of.
their issue, which has been considered by the Supreme Court, is only one of the many issues.
Lordship, yes.
Well,
One of the major issues.
My limited understanding of that matter, filed by Mr. Ashwini Upadhyay before the Honorable Supreme Court, is with regard to religious minorities. It has nothing to do with linguistic minorities. That's apparent from the order. If my learned friend is saying something like this, let it come by way of an affidavit. We will respond appropriately.
No, my stand,
And
Lordship.
whatever is the position, that's there in the Honorable Supreme Court, we'll bring it before your Lordships.
Lordship, my only respectful stand is this, since whether it's an issue of linguistic or religious, matter is pending, because here the stand of the Supreme Court or central government is very important.
Let that also come by way of an affidavit from the state.
Lordship, admittedly, when I read out para 6, it says clearly that the central government stand is this has to be decided by central government. Now, central government has to come before further deliberation in this matter as to whether the subject matter is same in the Supreme Court or this has got independent status.
They don't have, as he said, but joint secretary or additional secretary has to be called.
And central government should come out with a stand, because Lordship will recollect in the day of motion.
Let the affidavits come,
Lordship, in the day of motion, the issue involved was whether 52nd report, state should act or not. There's a deliberate order, a long order passed by this Honorable Court in the day of motion. Within the 52nd report, and I read out Article 350B, says there is an exchange of letter between the Joint Secretary and the President of India. Now, I read out 350B and says the President has to communicate back to the state. Now, it will be too premature, Lordship, to entertain this PIL without getting a clear stand as to what is the stand before the Supreme Court and whether this case stands on an independent footing. Number one. Number two, they are seeking a Lordship. One of the prayer is for disposal of representation. Admittedly, they have filed 3-4 representation to the chief, to the government of Meghalaya. In light with the Sain Raj, para 6, maybe the PL, if supposing after the stand of government, we will be left with one option, either to dispose of the representation within a given time.
I must.
If not, Your Lordship, if not, that stand will become clear only when the central government files an affidavit. Now, central government is yet to say whether 350B, recommendation
Whatever
of
my learned
350B.
friend is saying, I'd only pray, let it come by way of an affidavit.
That is exactly we're submitting. Let the central government come.
I'm saying let the state file an affidavit also.
No, we are not in the position to file, because if the inquiry report itself is not binding on the state, once they say binding, Your Lordship, the logical conclusion will be we'll have to dispose of the representation. And the only thing is this, we have to call out whether in case of linguistic minority, whether this is binding on us. Then that will at least give a rest to this issue.
Tantamount to giving the state an open field, Millets, to choose what they want to do. Whatever is their position, they have to come out with a concrete position before my lords.
The central government is not appearing. Full stop.
Your Lordship,
My lords,
I need some time.
Oh, you're sorry.
Central government is here before, my lords.
The petitioner, comma, the state government and the central government are directed to file very short affidavits stating to what extent this court retains jurisdiction to entertain, try and determine this public interest litigation. In view of these are different cases.
One, my lords. WPC.
Lordship, some was for impleading. The main case is 836, Your Lordship. The principal
The
case,
main matter is WPC
836.
number 836 of 2020, my lords.
This was ancillary orders passed by impleadment by further direction.
Remember, various IAS filed by various parties, my lords.
Various parties.
All right. In WP number 836 stroke
Lordship, 2020.
20, Ashwini Kumar Upadhyay versus
Union of India and others.
Union of India.
Union of India and others. What have you written?
The petitioner, common state government and central government are directed to stating to what poor victim try and determine this public interest litigation.
It is not mentioned.
In view of pendency of that I told you, Ashwini Kumar Upadhyay was the Union of India and others. WP Civil 836 of 2020 before the Supreme Court. This writ wants direction from this court to fulfill the mandate of Article 350 capital B of the Constitution of India
Just go to the Supreme Court and just see in this the state of Meghalaya is one of the respondents. अभी पता पड़ गया. I think Meghalaya is participating.
for protection and enhancement of the rights of linguistic minorities in India. The affidavits ought to be filed before the next returnable date. List is public interest litigation on 12th August.
We'll assist your lordships, my lords. What is the position there?
Yes.
We'll try and assist my lords. What is the position there in Delhi?
Number 4.
Ali.
My lord.
Yes, please.
My lord, yes, my lord. It's a writ petition, my lord, challenging the 2 Amendment Act of 2018, my lord, whereby 2 sections were amended in the parent act, section 2E and section 1, my lord. My lord, before starting my argument, my lord, I'll just like to submit the brief facts, my lord.
Fact not available. Yes, Mr. Hassan.
Yes, my lord. Before start my argument, I'll bring the basic facts, my lord. Prior to 1992, my lord, in the state of Meghalaya, the primary school teachers were governed and ruled by the GHDC, Garo Hills Autonomous District Council, my lord. Due to the failure on the part of the GHDC to manage the affairs of the lower primary school teachers, the government of Meghalaya intervened, and in the year 1980, they appoint the administrator, my lord, which powers flows from 6th schedule, my lord, of the Constitution of India. And ultimately, the government of Meghalaya coming out with an enactment called Meghalaya Taking Over of Lower Primary District Council Act, my lord, 1993. Under the Act, my lord, Section 3 has provided some benefits in the form of arrears, gratuity, allowances, salaries were given to the lower primary school teachers, my lord. Thereafter, my lord, the benefits were not released to the teachers. Then teachers were approached before the Honorable High Court and benefits were released to the LP teachers, my lord. But, my lord, the pre-primaries were left behind, my lord. Only the LP teachers were released the benefits. Now, thereafter, my lord, pre-primary school teachers were approached this honorable court, my lord. Then learned single judge of this honorable court, my lord, write order dated 17/5/2017 at annexure 4 of my writ petition had held that since the definition clause of the parent act, section 2E, is silent about the pre-primary school teacher, and held that those pre-primary are also functioning as working and functioning under the same umbrella like primary teachers, also within the ambit of the section 2E, and directed the state government to release the
17th May 2016.
17 May 2017, my lord, the order of the learned single judge. Thereafter, my lord, the state government has filed intercourt appeal before this honorable court. And after hearing at length, the honorable division bench of this honorable court, my lord, after discussing the aims and object of the parent act, upheld the order of the learned single bench, my lord. And the order of the learned division bench was attained finality. Thereafter, my lord, the state respondent come out with a 2 Amendment Act in the year 2018, my lord, whereby Section 2E was added and excluded the pre-primary teachers, my lord. And Section 1 was also added by the amendment, 2 amendments, my lord, where Section 1 talks about, my lord, cut-off date of implementation. This is the facts, my lord, the basic facts of the case, my lord. Now, my entire argument is on twofold, my lord. Number one, by the Amendment Act, the legislature has encroached into the power which the court has, my lord. The judicial overruling of the binding decision passed by the learned court. Then second argument is on Article 14, my lord. By this Amendment Act, this 2 Amendment Act is discriminatory in nature, arbitrary, and third is, my lord, classification, my lord. Because of this Amendment Act, they have created a new class within the class, my lord. So I would like to refer, my lord, one judgment, my lord. I submit the list of books, my lord, on the last occasion. My lord, 1995.
6 SCC 16.
Yes, my lord, 6 SCC, volume, page 16.
You
my
first shows the impugned order.
My lord, yes, my lord. The impugned amendment, my lord. My lord, page 56, my lord. Annexure 8, my lord. Page 56, Annexure 8, my lord. My lord, come to page 57, the next page. May I read, my lord? The amended portion, my lord.
Yes.
My lord, yes, my lord. The amendment of Section 2, my lord. In Section 2 of the Meghalaya Taking Over of District Council Lower Primary School Act 1993, hereinafter referred to as the Principal Act, for the existing clause E, the following shall be substituted, namely, DCLP school means any primary school including basic school, junior basic school managed by the district council but excluding the pre-primary section. That is where we are hit, my lord. Excluding the pre-primary section, my lord. But before this amendment, my lord, the definition was kindly have, my lord, the Parent Act, my lord. Kindly have the Parent Act, my lord. At page 33, my lord, the Parent Act, my lord. Page 33 of my petition, my lord, the Parent Act. The Section 2 definition clause, my lord. Section 2 subclause E. DCLP school means any lower primary school including a junior basic school managed by the district council. That is the only definition, my lord. This has been...
Amendment is at page 59.
Amendment is at page, my lord, 57, my lord.
But at 59.
My lord?
At 59. Oh, 57.
57, my lord, the first amendment.
Yes.
the section 2E has been added, my lord, whereby pre-primary, the petitioners, has been excluded, my lord.
All right.
Thereafter, my lord, by this amendment, we are excluded, whereby it's a clear case of violation of Article 14 in 3 counts, my lord. In 3 counts. Number 1, arbitrary. Second is discriminatory. Third is, my lord, classification. They create a new class among the class, because the DCLP, District Council Lower Primary School, is itself a class of teachers, my lord, who are working under the same umbrella as the lower primary school.
Where is the Parent Act?
Parent Act is at page, my lord, 30, start from 33, my lord. 33. 33, definition clause, section 2.
Page?
Page 33, my lord. The original act, my lord, Parent Act, the Parent Act was originally silent with regard to pre-primary.
Single bench. But pre-primary was there before.
Pre-primary was not there before. It was silent. The act was silent. When they come before the learned single bench, my lord, the learned single judge, after hearing the matter, had
Yes, Justice Sen's judgment.
Justice Sen's judgment, and the same was upheld by this division bench of this honorable court.
But what did his lordship rule?
My lord has single judge has ruled that since the Parent Act is silent with regard to the pre-primary, and their working and their working conditions, and they are teaching the same schools, also that means also within the ambit of the definition clause, that is section 2 subclause E, and as such directed the state government to release the same benefits which is given to the primary teachers, my lord.
We will continue tomorrow. There is a single bench.
My lord, if
Heard Mr. Hassan for the petitioner. Hearing shall continue tomorrow.
my lord.
List the application accordingly on 23rd.
My lord. My lord. I'll your best.
Yes. Single bench sitting immediately.
Yes, my lord. I'll your
Yes, please.
I was informed that Dr. Mozika is unwell and they are going to seek an adjournment.
All right. On the prayer made on behalf of the Deputy Solicitor General, Dr. Mozika, this application is adjourned till
May it please, Lordship. Lordship, in this matter, I pray for some accommodation, Your Lordship, as the learned DSGI, Lordship, is having severe back injury, Your Lordship.
who? Mr. Kumar?
Mr. Dr. and Mozika, Lordship.
Back injury?
A back injury, yes, Your Lordship. Slip disc, Your Lordship.
When he had it?
Yesterday, Your Lordship.
All right. 20,
Lordship, if I may pray after 2 weeks, Lordship.
no. We are placing it on the 30th. I'm sure he will be all right. 30th July. At a time to be indicated in the list. This matter has to be finished before I retire. I don't want to keep it hanging.
Very wish.
Yes. It is highly desirable that no adjournment is sought and efforts are made to conclude hearing of the matter as early as possible.